What can parties do to mitigate the risk of international contract disputes?
See, in contracts, usually we have a two kind of process, like having a good faith negotiation and then the arbitration proceedings. Like you can have different levels of conciliation proceeding before the arbitration itself. So, for example, you have a first level with engineering level people, and then the management level, and then you go for the next level people. Then you go for an arbitration. So, if you can't resolve a dispute at first level, at least you can try to resolve it at the third level without going for an arbitration, which will reduce the cost. This can prevent international commercial disputes and like arbitrations. Yeah.
Are you satisfied with the straitjacket DR processes like mediation, conciliation, and arbitration, or you feel there is a lot of scope of hybrid methods like MEDAP or ARB-MEDAP, etc.?
I have a complex answer for this. Like, say, I'm satisfied with the arbitration, conciliation, and mediation processes, straitjacket processes. But in terms of conciliation, what happens is in India especially, people come for conciliation meeting, and they agree to disagree at the end of the day. So there is no point of having a conciliation meeting for that. Similarly, if you go for a MEDAR procedure or MEDAR procedure, which is now based out of the Singapore Convention, you have a opportunity for the party to delay the proceedings by 8 weeks. So which is also a pitfall there, and we have to wait and see how it is functioning.
Do you feel arbitration has become so complex, burdensome, or regulated that it is now similar to court proceedings?
Yeah. Most of the dispute arises because of non-performance of the either party. So the moment the party doesn't want to perform a contract, they also don't want to perform their obligations under the contract, wherein they have to appoint an arbitrator as well. So they delay the appointment of arbitrator. Then we have to move for Section 11 in the High Court, and then the appointment happens. Then the arbitrators delay the process of appointing a presiding arbitrator. Again, you go for a Section 11 for presiding arbitrator appointment. So this is how it is being regulated. Probably the new amendment of 2019 probably will answer this question by way of institution of arbitration concern.
Okay. Last question, your experience at TI?
It was a nice experience, like starting from the hospitality and the entire session, jam-packed session of whole day is good. But I felt like the time given for each topic could have been little much more. Instead of being a 1 day, it can be a 2 day conference of that kind.
Definitely will look forward to it.
Thank you.
Thank you so much.